Hello, this message is brought to you by the Contra Costa County Bar Association's Lawyer Referral Information Service. I'm a lawyer in the San Francisco Bay Area and a certified specialist in bankruptcy law. I'm here today to go over some common issues that arise when a person is thinking of filing for bankruptcy. When a person is thinking about bankruptcy, they are usually at a critical point. They are having cash flow problems. They are being sued by a credit card company. They are being garnished by the IRS, or their house is about to be sold at a foreclosure sale. Bankruptcy should be viewed as a helpful financial tool that is available for most people in these difficult situations. The two most common types of bankruptcies are Chapters 7 and 13. To properly determine which is best for you, you should start with collecting all of your bills and obtain a copy of your credit report. Then, make a list of your assets, but also state the approximate values of those assets and any accompanying secured debt like mortgages, equity lines, and car loans. Lastly, make a simple budget consisting of your expected monthly income and monthly expenses. With your financial data in hand, you're now ready to determine what bankruptcy can do for you and which chapter is best for your situation. Before we begin, you need to know three things that are applicable to either chapter. First, both types of bankruptcies give you an automatic stay of all collection activities immediately upon filing your case. This means that wage garnishments, bank levies, lawsuits, foreclosures, and other collection activities must immediately stop when the case is filed. As soon as you file, you can give a creditor your bankruptcy case number, and they must cease collection. In the case of a foreclosure sale, the sale cannot proceed. Second, in any bankruptcy, you're entitled to exempt a certain amount of your property. If you own a house and have equity, you can exempt from $75,000 to $175,000. If you do not own a house, you can exempt approximately $24,000 of general assets like cash, bank accounts, and car equity. Note that we are talking about equity. If you have no equity in your house, you can still file bankruptcy. But you have to decide whether you're going to keep the house and continue making payments or let the house go to foreclosure. The same concept applies for a vehicle with no equity. Either continue making payments or give it back to the lender. Note that you can also exempt other types of assets like 401ks, IRAs, and personal injury claims and household possessions. Third, your goal in any bankruptcy is to obtain a discharge. A discharge is a final order from the court that certain debts existing as of the date you filed for bankruptcy relief are permanently forgiven, and creditors are barred from ever taking any further collection actions. Not every debt is discharged in bankruptcy. Common debts like credit cards, repossessions, and unsecured loans are discharged. Other debts like child and spousal support, student loans, and newer taxes are not discharged. You next need to determine if Chapter 7 can work for your situation. Chapter 7 is commonly called the Fresh Start Bankruptcy. In the basic case, an individual filing Chapter 7 normally has few assets of any value and has insufficient income to pay his unsecured debts, normally a bunch of credit card debt. You petition the court to discharge your debts, and the court reviews your situation, including your past and present income, and if in fact you have no ability to pay any portion of your debts, then you can receive a discharge. People like Chapter 7 because if you qualify, it is normally a quick process, as you can obtain a discharge in as little as 3 months after the case is filed. It stays on your credit for 10 years, but in most cases you can obtain a good credit score, again in as little as 3 years. Alternatively, Chapter 13 may be a better option for you. Individuals with a regular source of income can utilize this type of bankruptcy to reorganize their debts. Why would someone want to reorganize their debts? Well, you may be behind on your car payments and unable to get caught up. A Chapter 13 bankruptcy filing would prevent a repossession and give you the opportunity to restructure the car loan with possibly a lower interest rate and over a new term. As a result, your car payment might be lower than it was pre-bankruptcy. You may be facing foreclosure. A Chapter 13 bankruptcy filing will allow you to stop the foreclosure process and pay the mortgage arrears over time in addition to your regular monthly payment. You can also repay recent IRS and Franchise Tax Board taxes over time. The mechanism is a Chapter 13 plan. which is your proposal to the court and creditors on how you are going to deal with your various debts. If there are no objections, the court will usually confirm your plan about 3 months after you file your case. Your repayment plan is normally 3 or 5 years, depending on your income level. Like Chapter 7, you get a discharge, but not until you have completed making all of your planned payments. Please note that bankruptcy is far more complex than what I've had time to go over today. Everyone's situation is different. The best possible way to evaluate your specific situation is to receive advice from a competent attorney who works in the bankruptcy field. The Contra Costa County Bar Association's Lawyer Referral and Information Service provides a panel of pre-approved and highly qualified bankruptcy lawyers who do just that. They can use their knowledge of the law to help you explore your options and make an informed decision. I hope you have enjoyed today's presentation.